Please the court, my name is D. Hobbs, along with Alvin Bell, who is the oldest still practicing member of the Tennessee Bar. I will simply say is beyond his mid-90s. We are here representing the appellants in this matter, two brothers, and the siblings of the deceased, who is the subject of this estate matter. This case is, frankly, factually fascinating. In 1968, Elise Moon executed a will that, among other things, provided that all income and any distribution of corpus regarding a grandchild would be free from the claim of any spouse, either during the beneficiary's life or after their death. In other words, it would be rather inclusive of all reach of someone outside this family bloodline. This will also included a power of appointment. The power of appointment enabled each child. Now, the late W.D. Moon, who was the trustee of a portion of the trusts that were created under this will, was also a child of Miss Moon. Ergo, he had the authority or the ability to change the ages of distribution of the corpus of this circumstance. He indicated, and it's in the record, that he exercised that authority on two different occasions. The distribution ages, as originally stated in the will, were 27 and 32, half at 27, half at 32. Obviously, when the decedent reached age 27, she did not receive half of the distribution of corpus, and when she reached age 32 in 1989, she received no distribution of corpus. The funds that made up this trust, known as Mary's Trust for everybody involved, were literally held and distributed for decades by a number of corporate co-trustees. The old American National Bank was the first trustee, and in fact, when the decedent turned age 32 in 1989, there still was an American National Bank in Chattanooga. There would be a number of various corporate co-trustees that followed. The record will show that the decedent complained to her brother, at least one of her brothers, that Dad had not given her the share of the trust that she thought she was entitled to get, but she never requested of the trustee himself that he relent and in fact turn over corpus to her.
What was the reason for not distributing at 27 and 32?
Mary lived with him in her 20s. He had the opportunity to see her. He had the opportunity to determine whether she was prudent in her spending. Plus, the appellee makes a lot in the record about the fact that the two brothers also received their distributions free of trust and were very imprudent in handling it. He wanted to take care of Mary after his death, and pointing out she also received distributions of income along and along. By the way, I do apologize. I would like to reserve 2 minutes for rebuttal. Just 2 minutes.
That'll be fine. I should have asked you.
Thank you.
We both boopsed. Go ahead.
So, various co-trustees for a number of years, and in 2008, a local new Chattanooga trust company, what is today known as Southeastern Trust Company, or SETCO, took over administration of the trust. SETCO had the parties, including the decedent, including Mr. Moon, including the two claimants in this matter, the brothers, sign, and by the way, the spouse, the appellee here, sign a non-judicial trust settlement agreement, which obviously acknowledges the existence of a trust. So from 2008 until 2014, this fund continues to be administered as a trust. It looks like a duck, it quacks like a duck, ergo it's a trust duck. In December of 2008, Mr. Moon, the late Mr. Moon, resigned as a trustee. there would never be another co-trustee. Setco would be the only trustee from that point forward. There was a change in leadership there, and in 2014, it was determined based on a routine file review that, wait a minute, this trust, it shouldn't exist anymore. It doesn't exist anymore. It ended in 1989 when the beneficiary reached age 32. They informed Ms. Ballard of this. By the way, there's no indication in the record that Mr. Moon, Doc Moon, was informed of that, nor either of her brothers, be that as it may. Her response was, one might expect, oh, well, give me my money. But no, she insists that the money continue to be administered in a trust, that she would begin, and she did begin, providing input on investments and so on and so forth. So frankly, despite numerous admonitions on the part of Setco to dissolve the trust, in other words, they used the term break the trust, despite that, she wanted it to remain in trust. In 2016, Setco demanded that the trust be dissolved. Her response was to simply take the money and put it into an agency account in her own name with no payable on death beneficiary. Earlier, she had requested Setco to continue to inform her father, continue to send him statements regarding the activities and the investment portfolio.
And this is all in the record, what you're telling us?
This is all in the record,
all
yes.
Right. All right, so in 2016,
In
2016, the trust was closed.
It was.
And the money, all the assets left in,
right,
were distributed to her and put in an investment account.
Judge Sweeney, if this case falls on...
First, is that right?
Yes, sir.
Okay, thank you.
If this case falls on the imprudent and inappropriate decision by Setco unilaterally to decide that this trust shouldn't exist and terminate without benefit of what the trust code offers when there's questions of trust interpretation, without giving the parties any opportunity to weigh in on this, that is a separate issue. There is related litigation in this matter. Because what I have related through 2016 is this. There was a trust. It was treated as a trust. In 2016, it was dissolved. It was moved into an agency account, and that's where it existed at the time of the decedent's death. The trial judge overruled our motion for summary judgment. However, what is unusual here is that there would be a further hearing, additional argument, and additional conclusions of law made before the jury was convened and we had a trial. With all respect to the chancellor, who deserves a great deal of respect, it is as if he determined that I set a jury trial, we're going to have a jury trial on something. Because what he found as a matter of law was, number one, this is a bloodlines provision. And there's nothing unenforceable or invalid as a matter of law in and of itself. And number two, the extension of ages even through 85 and 87, which is in the record as what the final extension was, is not invalid of the law in and of itself. The party stipulated, the court noticed this, the trust continued to be administered. Quarterly checks were sent to the decedent by the trustees long after the decedent had turned 32 years of age. Further, the party stipulated, the stipulation is in the record, funds had been held in a trust account, they were not commingled with other assets, they were clearly identified as coming from the estate of Elise Moon and into Mary's trust, and the appellee made no deposit of additional funds into the account. So, any issue of transmutation or commingling is simply not before the court here. The court determined that if the intent of the will is carried out, and this is a contention with which we agree, the spouse cannot receive proceeds of the trust during her life or after her death. We assert that the lower court erred in failing to recognize that the assets of this trust could not be paid over to this residuary beneficiary because of the clear provisions of the bloodline part.
The assets weren't paid from the trust, were they?
I'm sorry?
Yeah, I'm sorry. The assets weren't paid from the trust, were they?
The assets, the trust was dissolved in 16. It went into an agency account.
In the decedent's name.
That is correct.
And so the residuary beneficiaries to that account received the funds.
That is correct. That is correct. And again, to the extent the decision of SETCO there is determinative of this appeal of this case, then again, that's not before the court. There's related litigation involving that. We believe that the trial judge misapprehended the effect of the payment by SETCO into that agency account, because even afterward, Mary continued to keep the funds separate from any other assets. She had no payable on death designation. She had no joint ownership. And frankly, the only reason that the trust was quote unquote broken in 2016 is because SETCO said, we're no longer going to administer it as a trust. You're going to have to do something.
And SETCO was the sole trustee at that time.
That is correct. It was the sole trustee at that time. As far as the jury verdict is concerned, well, first off, there shouldn't have been a jury. Based on the rulings made after the motion for summary judgment was denied and pre-trial, it should have been determinative of all issues before the court. The court could have ruled as a matter of law that bloodlines provision existed. It was still in effect. Mary had died at the time that she had died. The trust corpus is still there. Granted, what Judge Sweeney says is correct. It's no longer identified as a trust account. It's an agency account, but it has not changed. Reasonable minds, meanwhile, could only conclude that these proceeds, clearly identified, never commingled, would pass outside of the probate estate and instead would pass in accordance with the intent of the grandmother, Elise Moon. The lower court determined that the trust terminated in 1989. That determination is contrary to the law, and it's contrary to the facts in this particular case. To give effect to the intent of Ms. Moon, making that sort of determination was immaterial, wasn't necessary, and in this case, it worked an injustice. The jury was allowed to make a construction of the Moon will that was beyond the scope of its responsibility. In the charge, among the things that the jury had to determine was whether the decedent ratified the conduct. It acquiesced in the continuation of the trust. Bear in mind, from the time she turned 27 until the time she stubbornly agreed in 2016 that the trust assets should be modified or altered. She always clearly recognized the existence of the trust. In the absence of any proof that she failed to consent to or acquiesce in the continuation of the trust, this court should treat the matter as a trust, or treat the asset as a trust. I'm essentially out of time. If I may yield, unless there are questions, I will have rebuttal.
Yes, you have your time for rebuttal. Thank you. Hear from the appellee.
Good morning. I'm Ira Long from Chattanooga, and may it please the court, I represent the personal representative in this case, who is Mary Ballard's husband. The facts in this case are convoluted, but if you'll bear with me, if I were to tell a neighbor about this over the fence, and I'm telling Court of Appeals judges, obviously not a neighbor, I would explain the big picture like this. A grandmother wanted to pass her wealth on to her grandchildren. So in her will, she established a testamentary trust which provided that her grandchildren would receive 1/2 of the corpus at age 27, with the remainder trust termination at 32. A fairly garden variety distribution of assets. The will provided for a power of appointment to the grandmother's son, the father of Mary Ballard. It conferred on him a power to modify those ages of 27, and we say only 27, not 32. We see that as a hard date for trust termination. What he did was he changed those dates of 27 and 32 to 85 and 87. And those dates...
Did the trial court find that the letter was sent? I mean, you say that he changed this. It was a letter found, or sent him a copy of a letter found in his records, but not in the bank's or the trustee's records. Is that right?
That's right. The allegation was that the father executed a letter, delivered it to the corporate trustee, and said, I changed the ages to 85 and 87.
That was a copy of a letter found in his records, not in the trustee's records.
Actually, attached to the complaint was a copy of a letter.
I'm sorry.
Attached to the complaint was a copy of a letter. The original letter, if there was an original letter, and we never agreed there was, its whereabouts, what happened to it, is unknown.
Did the trial court find that the letter was or wasn't sent?
No, the trial court did not. We believe that the trial court should have decided that the letter, if in fact it was sent, was ineffective, because the original dates were 27 and 32. The letter changes not 27 and 32 to 85 and 87. The letter changes the dates of 32 and 37 to 85 and 87. The position of the appellant is that, well, there must have been another letter, a previous letter that changed the dates from the ages, from 27 and 32 to 32 and 37. Nobody has that letter. Mr. Moon testified by deposition. This is the father who purportedly wrote the 1986 letter. He was not able to ever say that he wrote a prior letter. He was asked, and he gave some confusing answers. His thought process was cloudy during his deposition. So I would say the neighbor would say, can he do that? Can he take these young adult ages that the grandmother chose that are garden variety, and we cited a case where the Supreme Court said they're garden variety, and change those to add 58 and 55 years to those beyond her life expectancy? We believe that the intent in the four corners of the will is that the grandchildren would receive her wealth when they're young adults. That he couldn't change the age of 32, but even if he could change both ages, that is not at all consistent with the grandmother's intent. And there's nowhere in the will that would indicate that she desired to give him the power to change those ages that much. What he had was a limited power of appointment. There are two kinds: of general power of appointment, which, well, I was not able to find any case where a power of appointment has been used for this. Typically, the testator confers a power of appointment on someone to dispose of their property in a manner that's within their discretion. And I'll take it back. With a general power of appointment, the donee, the power holder, general power of attorney, can appoint the assets to anybody, including themselves. A limited power of attorney, the power holder has a choice given by the testator of persons to appoint the assets to. For example, I give my coin collection to my nephews as the power holder sees fit. Power holder can't get any of it. It's for the nephews. Can use his discretion. It's usually done with real property, an appointment right with real property. This, I was unable to find any case where power of appointment was used for this purpose to change ages of distribution. Now, why did he change those? Mr. Hobbs indicated that he did so because Mary was a spendthrift. The testimony in the case, excuse me. The testimony in the case by one of the claimants, the older brother, was that when Mary was, I believe, 21, on New Year's Eve, she had been cited, arrested for public intoxication. She never had any other criminal offense that we know of in her life. What her father said at that point in time to the older son was, she's never going to get the money. And I argued to the jury that if you had a child who was 4 years old or 15 years old, and you could assure somehow that the worst thing they would ever do to violate any law would be public drunkenness on New Year's Eve, then some people would say, I think I'll do that. That's not so bad. And he never, when he made these changes, he could have changed them again. He never did. So we can't find that intent in the will. It seems to be completely inconsistent with what the grandmother chose. I agree that the case should not have been tried because the four corners of the will provide the answer. And we have in Tennessee, the law as I understand it is that if there's an ambiguity in a will, it's either a patent or a latent ambiguity. A patent ambiguity appears within the four corners of the will. It's up for the court to interpret the will. Jurors are not trained in how to interpret wills. The other type of ambiguity is a latent ambiguity. That is a situation where one must look to external circumstances. I give my coin collection to my favorite nephew. Who's the favorite nephew? A jury can figure that out. That doesn't require any coercion, trust in estates. In this case, there was no latent ambiguity. And we don't believe there was any patent ambiguity. But if there was, it was up to the trial judge to interpret the will based on ascertainment of the testator's intent. And this testator chose ages of 27 and 32, and the provision that provides the power of appointment says that he can direct a different age in the singular for distribution. We believe that age is 27. And if one construes this will to be age 27, can be changed. Could be younger age, could be an older age. But 32 is termination. Then the will makes sense. It makes sense because you have a cutoff date that is consistent. What is not even rational is what this father did. He changed these dates to 85 and 87, which is almost cruel. Those dates are beyond life expectancy by 10 years or so. And if the intention was that this daughter was immature and would be a spendthrift and would waste money, then why move the ages to 85 and 87? Is she going to mature any between 85 and 87? She's probably going to deteriorate in her abilities to manage money. And so I do want to talk about the bloodlines argument.
Well, I want
Yeah,
to ask
sure.
you questions, though, or a question. Help me with what the trial court submitted to the jury.
The trial court submitted 3 questions.
Were they fact questions, questions of fact?
I'd say they were questions of mixed law and fact.
That's always my answer, that it's always a mixed question of law and fact, because I can never figure it out. But go ahead.
The questions were, did Mr. Moon comply with the requirements of the will in changing the ages? The answer is no, because there is no letter changing the ages from 27 and 32 to 32 and 37. Those are the ages he changed, but we don't have a first change. Did he, and the case law is that a exercise of a power of appointment must be in conformity with what the will says. It doesn't give any special powers as he, in his sole discretion, not to be challenged by anyone, and I cite a case for that. Was it changed? The second question was, it was changed to 85 and 87 within the discretion of Mr. Moon. That really goes to intent in the will. There's no extraneous circumstances that should have come into evidence about what the testator's intent was in terms of his ability to change these ages. And the third question was, did Ms. Moon ratify consent or acquiesce to the continuation of the trust? A trust officer testified that essentially we pulled this will out. We'd had it for a few years. There'd been a number of trustees. We dusted it off and we read it. So what is going on here? It says 27 and 32. They didn't have that letter. They told Ms. Ballard, this is your money. You have to take it. We can't hold this trust. She didn't resist and fight for no reason. The trust officer testified on cross-examination. I asked her, what's the other side of the story, like a Paul Harvey situation? She said, I don't know. What are you talking about? She testified that every time they asked Ms. Ballard to take the money, every time they tried to convince her, and they did it often, she said, I refuse to take it because I'm scared of my father. And eventually they put their foot down and she had to take it. But that's why she was, and there was other testimony in the record from her husband about how she came home from her dad's house in, tears and upset. And you can imagine if he changes these ages to beyond death because she has a public intoxication at 21, then it's just not a rational thing to do. The bloodlines argument, this provision that's called bloodlines argument is one sentence that appears in this spendthrift clause, and it says that these assets will not go to the spouse. In other words, payments from the trust won't go to the spouse. Well, as the court pointed out, they didn't go from the trust. Mr. Ballard collected those funds into the trust account where they still are. It's $400,000. Ms. Ballard's will doesn't prevent him from receiving this money. It prevents him from taking direct payment, for example, for alimony. If it was a community property estate, for the payment of debts. It doesn't say former spouse. If they've been divorced, he could have the money. It's only if he's married. And that doesn't make sense either. Thank you.
Thank you. Hear from the appellant rebuttal.
The decedent was so afraid of her father that she insisted to Setco that he continued to be provided copies of all the records of the investments. The appellee has just noted that he, referring to Doc Moon, changed the dates. We're not dealing in any fiction on this side of the lawsuit. There's no ifs, ands, or buts about it.
I didn't understand him to say that he agreed that the dates were, that the proof was the dates were changed.
In fact, Your Honor, I believe he stated literally, he changed the dates, that the letter was not found. All of these were matters that were before the court that a jury didn't have to decide. The fact that the original letter was not in Setco's file was a matter that everybody acknowledged at the time. On the other hand, Setco, of course, had the parties acknowledge the existence of a trust in 2008 when the non-judicial trust settlement agreement was executed.
How does it just make any logical sense that the dad would change the dates to beyond Mary's life expectancy?
Well, life expectancy did not mean anything, and the trial court found as much. The trial court found that the trust did not terminate as a matter of law. I'm quoting from the final pretrial order, upon her attaining age 32. There was income and later principal being distributed to her as a result. It guarantees an income stream for her the rest of her life. At the time that, and since the appellee made reference to the record, there was also reference to cult involvement during this time. These were things that would concern a father. Discretion in this matter was not a jury decision. We contend that by all operations of the parties, there was a trust, it was recognized as such, and it was administered as a trust for decades after what was provided in the will. My time is up. Thank you.
Court's thanks to counsel for both sides. I appreciate your arguments and your briefs on this. If you would, recess court till 1:30 this afternoon.
All rise. This court is at recess until 1:30 today.